Alaikum and a very good morning, students. Really? Can you hear my voice? Okay. Okay, so as we all know, this week is actually your midterm break week, but we still have to have class today because if we don't have class today, we won't be able to finish all our syllabus because we have around 6 more topics to cover. So I'm sorry that I have a class during your midterm break, but it has to be done. So for today, we will be learning on 2 topics. So first, we will be learning on topic 6, which is the third part in law of contract. Okay, so we have law of contract 1, law of contract 2, and then today we will finish off the law of contract with law of contract 3. So for today's class, what we will cover is we will cover on what type of contracts is considered as an illegal contract, contract yang menyalahi undang-undang. What type of contract is considered a void contract? So a void contract is a contract which is not enforceable by law. So if you have entered into a void contract, that contract cannot be enforceable in law. So you cannot take your case into the court to get any damages. And then we will also look on how to discharge a contract. So if you don't want to continue with the contract anymore, how are you going to discharge the contract? How to end your relationship in the contract? There are many ways. And then we will also look on the remedies. So if you are an innocent party who has been affected by the contract for any reason, so maybe one of the parties breach the contract, so you suffered loss. So how what type of remedies you can get, what type of damages you can get, so that is also will be covered under topic 6. Okay, so and then after we finish with topic 6, we will also be learning on one new topic, which is on the law of agency. So in normal situation, a contract is usually between the parties to the contract, so A and B. But in under the law of agency, there are certain situation where you can appoint someone else to be your representative. So a representative who can make any dealings on your behalf, a representative who can sign a contract on behalf of you, that person is called your agent. So that is what we are going to learn under the topic of law of agency. Okay, so for those who are in section 2, your presentation will start today. So if you have not send your presentation slides yet, please send it to my email by today because we will be having our presentation in the evening during our tutorial class. Okay, because I think 3 groups has sent their presentations, but and another 3 have not. So if you are in my tutorial group class and you have not submit your presentation slides, please send it before our tutorial this evening. Okay, so without further ado, let's start with topic 6. Okay, so before we start with Law of Contract 3, do you still remember what we have learned last 2 weeks? Last 2 weeks we have covered on Law of Contract 1 and Law of Contract 2. What have we learned during the last 2 weeks? Does anyone still remember? Does anyone still remember what have we learned last 2 weeks? Elements of a contract. Okay, so we have learned on the elements of a contract. Then what else? Other than that, we have 4 hours of class last 2 weeks, if you still remember. Other than elements of a contract, what else have we learned last 2 weeks? Contents of the contract. Yeah, consideration is under the elements of a contract, and we also learn all the contents of a contract. What type of contract is a warranty? What type of contract is a condition? What is implied term? What is exclusion clause, exemption clause? Other than that, there is one more thing that we have learned. Elements, contents, effects of voidable contract. So if you enter into a contract without uh, exclusion clause, exceptions to consideration, and then we also learn on the effects of a voidable contract. So a contract which is entered without free consent of the parties is called avoidable contract. So avoidable contract is the party who entered the contract without free consent has the option either to put an end to the contract or to continue the contract. So that is a voidable contract. And we also learn on the exceptions to consideration. What type of consideration is accepted? What type of consideration is not accepted? What privity of contract, the concept whereby only the people who are parties to the contract have any rights under the contract. That is the concept of privity of contract. And we also learn a bit on the type of person who does not have the capacity to a contract. A minor, someone who is under the age of 18, they cannot enter into a contract except for some type of contract, for example, as a contract for necessaries, a contract for scholarship. And then we also learn that a person who is of unsound mind, orang gila, they also cannot enter into a contract. Okay, so that's all that we have learned on law of contracts. So for today's class, we will continue on the last part of law of contract. So what we are going to be learning today is we will learn on what is a void contract. What is a void contract? What is an illegal contract? And then we will also learn on how to discharge a contract, how to put an end to the contract, how to discharge yourself from your obligation under a contract. And we also learn that we will also be learning on what are the remedies available for breach of contract. So if someone has breached a contract, or for example, a contract has become frustrated, a contract can no longer be enforceable, a contract can no longer go on, what are the remedies available for each party under the contract? Okay, so this is all we are going to be learning this week. So first, we will start on void and illegal contracts. So what is the difference between a void contract and an illegal contract? So when you call a contract voidable, In Malay, it is called contract. Hmm, I think it is. Yeah, avoidable contract in Malay is what we call it a contract boleh batal. So avoidable contract is a contract whereby you have the option. So because avoidable contract is entered into without free consent, so it means that one of the parties who has entered into that contract does not freely give their consent, does not fully agree, does not fully understand their agreement to the contract. That person can, they have the option to put an end to the contract. So that is what we call avoidable contract. So avoidable contract is contract. On the other hand, a void contract is a contract which is not enforceable at all under the law. So a void contract is what we call contract. So a void contract is contract yang terbatal. So a void contract is a contract which cannot be enforceable under the law at all. So that is the difference between a voidable contract and a void contract. So what are the types of contract that we considered a void contract? So under Section 2G of the Contracts Act 1950, a void contract is defined as an agreement which is not enforceable by law. So if the agreement is not enforceable by law, if the agreement cannot be used to get any remedies under the law, if the contract cannot be used to take the case to the court, that is what we call a void contract, because a void contract is not enforceable by law. So how to know whether a contract is a void contract or not? So a contract is said to be void if it falls under any of the categories stated in Section 24 until Section 31 of the Contracts Act 1950. So as I already mentioned to you last week, the Contracts Act have all the relevant provisions regarding how to, who are the parties to a contract, what is the type of contract which is void, what is the type of contract which is voidable. And if you look in the contract itself, usually each section will also have their own illustration. So illustration inside the acts is like an explanation, a simple example on how the section is put in effect. So how can you use the section? How the section is applicable? You can look on it in the illustration. So the illustration inside the Contracts Act is like an example for each of the sections. So if you want to look on what types of contract is considered a void contract, you can look in section 24 until section 31. So section 24 states on why does it become like this? Save to it. Okay, so the first provisions that talk about the type of contract which is a void contract. What is a void contract? Is under Section 24. So under Section 24 of the Contracts Act, a contract with unlawful consideration or a contract with unlawful object is void. So if the contract have unlawful consideration, meaning that, for example, you want to have a contract between two people, but the consideration, for example, the money which is going to be paid under the contract is a money which you get from fraud. So that is what we call an unlawful consideration. Or if the contract is for something which is illegal, for example, you want to do a contract with someone to hire a prostitute. So a prostitute is an unlawful object. So this kind of contract is void. So if you enter into a contract for to hire a prostitute, and then something happened, for example, you hire the prostitute and then um, you have paid, but they don't give you any prostitute. So you pay the money to hire the prostitute, but then they breach the contract by not giving you any prostitute. So in that situation, even if you want to take any action under the law for breach of contract, you cannot do so because that contract is a void contract because the object of the contract is unlawful. Okay, so under section 24, there are 5. There are 5 situations where a contract is considered a void contract, an unlawful contract. So the first one, a contract is unlawful if it is forbidden by the law. So if the contract is for something which is forbidden by the law, if the contract is for something which is not allowed under the law, the contract is a void contract. So the example of case which discuss on this topic, on this point, which is a contract which is forbidden by law, is the case of He Cheng against Krishnan. So what happened in this case of He Cheng and Krishnan? So in this case, the plaintiff and the defendant, He Cheng and Krishnan, they enter into a contract. Okay, so they enter into a contract. So in the contract, it was stated that the defendant agreed to sell to the plaintiff a house. So this is a sale and purchase agreement. So this is a sale and purchase agreement. So what happened in this case is the defendant agreed to sell to the plaintiff a house, which is built on a piece of land. So that land is a land given to the plaintiff under a temporary occupational license. So under the law, we have this one type of land, which is called a temporary occupational license land, which is you can get that land and you can build your house on that land, but the license to use that land is only for some temporary period. Okay, so you can use that land. So the land will be given to you. You can apply for a temporary occupational license from the land office, and you can use that land, and you can build your house on that land. So you will be allowed to use that land for a certain period of time. But there is this one conditions that if you want to get a land under temporary occupational license, you cannot transfer the license. So the license is granted to you by the land office for you alone. So you have no right to transfer that license to anyone else. So it means that you are allowed to build your house on that land. You are allowed to use that land, but you are not allowed to sell the land to anyone else because that land is given to you under a temporary occupation license. Okay, so what happened in this case is the defendant has sell the plaintiff a house built on that temporary occupational license land. So that contract is definitely a void contract because it is forbidden to transfer the license. So you have no right to transfer the land. You have no right to sell the land because you also got the land under a temporary occupation license. So when you transfer that land to someone else, if you sell that land to someone else, it is something which is forbidden under the contract. So when it is something which is forbidden under the contract, it is considered a void contract. So the transaction is void. So the plaintiff cannot claim any rights on the land because the transaction between the plaintiff and the defendant is a void transaction. It is a void contract. So that is the first type of void contract under section 24. So when the contract is something which is forbidden under the law, it cannot be enforceable. So the contract is void because the contract is forbidden by the law. So that is the first one. So for the second one, a contract which is of such nature that if permitted would defeat the law. So if you enter into a contract with the purpose of um, trying to get around the law, for example, you want to do, for example, that thing is not allowed, so you are not allowed to do it under the law, but because you still want to do it, you try to use a roundabout way, so an illegal way to get what you want. So if the contract is of such nature that if permitted would defeat the law, so if the contract is allowed to go on, um, it will be against the law, so that contract is also a void contract. So that this is discussed in the case of Tan Beng Hock. So in the case of Tan Beng Hock, in that case, this is a case of a logging license under the Forest Rules 1935. So in this case, the defendant held a logging license. So the defendant has a license to log. So they have he have a license to melakukan aktiviti pembalakan in Pahang. So he held a logging license under the Forest Rules 1935. Okay, so he have the logging license, but under the law, it states that it is prohibited to transfer that license to anyone else without prior approval in writing of the District of Forest Officer. So under the law, it states that once a person is given a logging license, if that person wants to transfer the license to someone else, so if that person wants to give the license to someone else, he need to have prior approval in writing of the District Forest Officer. So you cannot simply transfer your license without getting approval from the forest officer first. Okay, so in this case, the defendant agree to assign his right under the license to extract timber to the plaintiff. So in this case, just like what happened in the case of Hee Cheng and Krishnan, the defendant give his rights under the license to log timber, to extract timber to the plaintiff without getting the approval in writing from the district forest officer. So in this case, the court held that as the contract was illegal, because what the parties are trying to do is against the law, so the contract is a void contract. Okay, so just like in the case of Hee Cheng, in the case of Tan Beng Hock, if you want to transfer a license, but you don't want to get a prior approval first, the contract is an illegal contract. The contract is void. You cannot take any action against the defendant for any breach of contract because the contract itself is a void contract. So that is the second one, which is the contract is, if permitted, will defeat the law. So for the third situation, the third point is the contract is fraudulent. So if you still remember, last 2 weeks we already learned on the type of one of the situation where a contract can be a voidable contract is if the contract is a void contract. If the contract is found on fraud. So similarly, if a contract is a fraudulent contract, the contract is also void under the law. So this is discussed in the case of Palyanapa Chettiar. In the case of Palyanapa Chettiar against Arunasalam Chettiar. In that case, the plaintiff bought 40 acres of rubber land. So during that time, there is these regulations stating that one person can only have not more than 100 acres of rubber land. So I think maybe during that time, in order to prevent any kind of monopoly, so they put a regulation that one person can own only 100 acres of rubber land. So in this situation, the plaintiff, he already have 100 acres of rubber land. So when he want to buy another 40 acres of rubber land, so in order to avoid doing it against the law, so what he did is he transferred the land to his son. So the 40 acres of rubber land, it is bought by him using his money, but he transferred the land to his son under the name of his son as the absolute owner. So in the land title, his son's name is on the land title as the legitimate owner of the land. Okay, so he transferred the land to his son as the absolute owner, but the funds for the purchase comes from the plaintiff. So this is something which is usually done by people, by rich people. If you remember in many movies, in many dramas, many rich people will do something like this in order to defraud the law. So they buy something, they buy it using their own money, but they put the name of someone else on the property. So this is what happened in this case of Palanapa Chettiar. He put the name of his son on the rubber land, the 40 acres of rubber land. Okay, so the sole purpose of doing so was to defraud the relevant authority because he wants to get more land, but he don't want to get in trouble with the law. So he put his son's name on the land title. So few years later, the father sought to recover the property from the son. So the father wants the son to return the property back to him. So he wants, maybe during that time, the regulation is no longer there, or maybe during that time, he no longer have all the 100 acres of rubber land. So in short, he wants his son to return the land back to him. Okay, so he sought to recover the property from the son, but at this time, the son resisted the claim. So the son does not want to give him the land anymore. So the son said, this 40 acres of rubber land is mine because you already give it to me. So you cannot take it from me anymore. Okay, so the father claimed for the 40 acres of land at the court, and the court held. So this case comes all the way to the highest court in during that time in Malaysia. The highest court is Privy Council. So the Privy Council held that upon the transfer of the property by the father to a son, a presumption of advancement arose in favor of the son. So under the law, there is this presumption. There is this principle whereby it states that if a father gives something to his son, it is presumed that what you give your son is a gift. So, so under the law, there is this presumption that whatever a father gives to his son, it is presumed that the property is given as a gift in advance. So because after the father has died, the land would go to the son anyway. So the court have this principle which states that you don't have to wait until you die to give your property to your land, to your inheritors, to your son or your daughter. You have all the rights under the law. If you want to give your property earlier to your daughter or your son, you have that right. So you can use this principle of presumption of advancement. So whatever a father gives to his son is presumed given as a gift. Okay, so under the law, if the father wants to rebut the presumption, so if the father wants to tell the court that the land is not given as a gift, the father has to show to the court that, no, actually I don't want to give this land to my son. My true intention was not to benefit my son. I don't want to give this land to my son, but it is actually I actually did it because I want to defraud the authority, because I want to get more property, but I don't want it to be against the law. So that's why I give it to my son. So if the father wants to get the land back from his son, he has to tell that to the court. But of course, he don't want to say that to the court, because if he said that he wants to get back the land because he originally the purpose why I give the land to my son is because I want to defraud the authority. Of course, he will not be able to get the land back. So he cannot use that as an argument to get back the land. So the court held that since he has to rely on something which is illegal, since he has to lie to something which is not allowed under the law to get back the land, so the court will not assist him in enforcing the resulting trust. So in this case, at the end of the day, the contract, he cannot get back the land. So the land is given to his son, and the land will stay with his son because he cannot get back the land, even with the presumption, because of the presumption of advancement. Okay, so that is the case of Palanapa Chettiar. If you want to do something fraudulent, a contract is also void, so you cannot do it. And then if it involves or implies injury to another person, or if the contract involves loss, or if the contract will cause the other person to suffer loss, that contract is also a void contract. So that is discussed under the case of Sheikh Ahmad Al-Habshi against Putih. So in that case, what happened is the transaction is between two people who wants the plaintiff, wait, the defendant in that case, he wants to sell a property to the plaintiff. So the property is a property belonging to an infant. So the property is actually belongs to someone who is under the age of 18. So under the law, if a property is owned by someone who is under the age of 18, he cannot held the property under his name. So under the law, he have to put the property in trust. So someone else is going to be his trustee, and that person will manage his property until he turns the age of 18. So in this case, the defendant is the minor's trustee. So the defendant want to sell the property of the infant for under the which is under value. So so for example, if the property is the market value is around 100,000, he wants to sell it at 80,000, for example. So in that case, the agreement, because the agreement was to the detriment of the minor, because the agreement will be will not benefit the minor, because if the property is sold for an undervalue, for example, something which is the market value is 100,000 and you want to sell it at 80,000, you will the minor will suffer loss of 20,000 ringgit. So in that case, because the contract is not beneficial to the minor, because the agreement was to the detriment of the minor, the contract is void. So if you want to enter into contract, you have to make sure that the contract does not involves injury to another person. So if it will cause another person to suffer from any injury, the contract will also be a void contract. And then the last one is the case of Pearce and Brook, a contract which is immoral, or a contract which is opposed to public policy. That kind of contract is also a void contract. So the case of Pearce and Brook is a case of prostitute. So in this case, the defendant was a prostitute. So the defendant hired a carriage from the plaintiff. So the prostitute hired a carriage from the plaintiff on hire purchase terms. So he buy a carriage from the plaintiff and he pays for the carriage in installment. So the purpose the purpose of the prostitute buying the carriage is he wants to attract customers. So he wants to get more customers. That's why he buy a carriage from the plaintiff. So he paid the first installment for the carriage, but he did not pay for the second installment. So he defaulted on the second installment. And when he returned the carriage back to the plaintiff, the carriage was returned in damaged condition. So in this case, the court held that because the evidence showed that the coach builder, the owner of the carriage, know that the defendant was a prostitute when he hired the carriage, and because he knows that if the defendant wants to use the carriage for an illegal purpose, so the contract is void. So the court held that anyone who supplies something for the performance of an illegal act with knowledge that it was to be used for that purpose cannot sue for the price of it. So in this case, because the owner of the carriage know that the prostitute wants to use the carriage to do her prostitution activities, he cannot sue for the breach of contract because the contract is a void contract. Okay, so that is 5 situations whereby a contract is void under the law, which is discussed in under Section 24 of the Contracts Act 1950. Okay, so before we continue with the other sections, do you have any question on Section 24? Do you have any question on Section 24?
Ma'am. Hello, ma'am.
No. Okay, so if you don't have any question,
Hello.
we'll continue with the next section. which is section 25. So section 25, why? So section 25 of the Contracts Act states that a contract is void if any part of the consideration is unlawful. So if any part of the consideration is unlawful, if a contract is a combination between something legal and something illegal, the contract will still become a void contract. So for section 25, we can see the illustration, which is inserted inside the Contracts Act 1950. So the illustration said that A, Darshini, no, I cannot hear you. Did you ask any question? No, I can't hear you.
Hello, madam.
Okay, yes.
Okay, can you hear me, madam?
Yes, yes.
Okay, awesome. So, madam, you was explaining about the avoidable and avoid is different meaning, right?
Mm-hmm.
The avoidable means that I have wrote it here contract which we can cancel, and
Yes.
avoid means a contract which is been cancelled. Is that
Yes, yeah, yeah. So basically, a void contract is a contract which is void, meaning that it cannot be enforceable at all. A
okay?
voidable contract, you still have choice. If you want to continue the contract, you can continue the contract and get some damages. But if it is a void contract, you cannot continue with the contract will end because it is a void contract.
All right. So avoidable means we still have chance to cancel it.
You can cancel and you also have the option not to cancel.
Oh, okay, ma'am. Thank
Ah,
you.
okay. Okay, so for section 25, if any part of the consideration is unlawful, the contract is still a void contract. So the illustration states that A promises to work for B as a legal manufacturer of indigo and as illegal trafficker of other articles. So in this case, um, one person hire another person to do something which is some part of his work is legal and some part of his work is illegal. So for example, maybe someone hire you to be his secretary, for example. Someone hire you to be his secretary, but at the same time, he also hire you to become a hire killer. Okay, so someone hire you to do two jobs. One is a legal job. That person wants you to become his secretary. But at the same time, he also asks you to become his hired killer. So if he wants to kill anybody, you have to kill that person on behalf of your boss. So in that situation, because the contract part of the consideration is unlawful, because you have to do one legal job, but another one is an illegal job. So under section 25, the contract is still a void contract. So like in the illustration under section 25, A promises to do work for B, one as a legal manufacturer of indigo and another one as an illegal trafficker of other articles. So in consideration, B will pay A $10,000 per year. So the contract is void as part of the consideration is unlawful. So similar to the situation I stated just now, if you hire a person to be your secretary and your hired killer, and you promise to pay them 10,000 per month, that contract is also a void contract because part of the consideration is an unlawful consideration. So that is what section 25 is about. Okay, so under section 26, we already talked about section 26 when we talk about elements of contract. So under section 26, an agreement without consideration is void. So except in certain situation, there are three exceptions whereby you can have an agreement without consideration. But in normal situation, if an agreement does not have any consideration, so if only one party gives something to the other party and the other party does not give anything back to him, that contract is also a void contract. Okay, so that is for under section 26. And under section 27, an agreement in restraint of marriage is also void. So you cannot enter into any agreement to which does not allow anyone to get married. So you cannot get into any agreement in restraint of marriage. So that a contract which states that you cannot get married. Once you enter this contract, you are not allowed to get married. So that kind of contract is also a void contract under Section 27 of the Contracts Act. And then under Section 28 of the Contracts Act, an agreement in restraint of trade is void. So if you want to enter into agreement stating that I agree that I will not do any business with any other person um, throughout my contract with you, that kind of contract is void. But for Section 28, there are certain exceptions, which we are not going to discuss in our class. But if you look inside the Contracts Act, there are 3 exceptions for Section 28. So if your case falls under the 3 exceptions, you can have an agreement in restraint of trade. But if in normal situation, you cannot restrain anyone from doing a business with someone else. So the kind of contract is void. And then under Section 29, agreements in restraint of legal proceeding is also void. You cannot have an agreement which states that if anything happen to our contract, you cannot bring the case to the court. That kind of agreement is void. But similar to Section 28, Section 29 also have some kind of exceptions. So if your case falls under this exception, you can do it, but in normal situation, you cannot do it. We won't discuss in details on all these exceptions because it is not going to be in your exam, and it is also not in your syllabus actually. But if you want to know more on the exceptions, you can look inside the Contracts Act itself. And then Section 30, an agreement which is uncertain is also void. So if you enter into an agreement but you don't put it in certain term, what is you selling, what are you buying, what is you selling, what are you selling, what are you buying, how much is the price, how the for example, if you have 5 houses, which of the house is going to be sold. If the agreement is uncertain, that agreement is also void. And then the last one, if an agreement by way of wager is also void. So if you want to enter into an agreement involving wager is judi, involving betting or involving what is judi in English?
Gambling, is it, madam?
Yeah, gambling. Sorry, I forgot the words. Okay, so if the contract is for betting or the contract is for gambling, that kind of contract is also a void contract. With an exception that if the gaming or the wagering or the betting or the gambling company is licensed under the law, that agreement is not a void agreement. But if you have any betting or you have any wagering or if you have any gambling activities which is unlicensed or which is not allowed under the law, that kind of agreement is void. So you cannot claim anything under the agreement. Okay, so that is the types of agreement which is considered to be a void agreement or an illegal agreement. Okay, so next we will see on the consequences of void or illegal agreement. So what will happen if you enter into a contract which is a void contract? Or what will happen if you enter into a contract which is an illegal contract? Okay, so as a general rule, there is this principle under the law which states that the court will not enforce an illegal contract. Okay, so in general, a contract which is illegal or in a contract which is void will not be enforceable by court. But for someone who has entered into a void contract or if someone has entered into an illegal contract, Section 66 of the Contracts Act provides for the right of restitution. So it's not like if you enter into a void contract or you enter into an illegal contract, you cannot get anything under the contract. You still have the right of restitution. So under section 66, it states that when an agreement is discovered to be void, so if an agreement is void, or if a contract becomes void, so this is for situation where a contract which is a voidable contract, the person who received any advantage under the agreement is bound to restore it to the other party or pay adequate compensation for the same. So the law said that a contract which is void, yes, you cannot enforce the contract in the court, but you still have the right of restitution. You still have the right to get back any advantage that you have given to the other person. So for example, you enter into a contract, a void contract, and you have paid something to the other party. So the other party have to return the money back to you. And if the other party has also given anything to you, you also have to give it back to the other person. So the right of restitution is when both parties have to restore to each other whatever they have gained under the contract. Okay, so if the thing is no longer there, if the thing is no longer with you, you have to pay a compensation in lieu of restoring that thing. So this is discussed in the case of Ahmad bin Udo and Ng Ai Chong. So in this case, the two parties, they enter into an agreement. So the agreement is for the lease of paddy land. Okay, so one of the party have a paddy land, and then he agreed to lease the paddy land to the other party for 6 years. Okay, so the party who got the paddy land, pay 1,500 to the other party. So the person who wants to use the paddy land for 6 years, he paid 1,500 to the other party who is the owner of the paddy land. Okay, but even after the money has been paid, the the party who is the owner of the paddy land does not allow the other party to use the land. So he cannot use the land to grow his paddy. So because of this, the person who is who wants to use the paddy field, the paddy land, he take an action in the court to recover the sum paid. So he claimed for the he wants to sue for the breach of contract under the agreement, but the court said that the agreement was illegal because actually under the law, under section 3 subsection 1 of the Paddy Cultivators Ordinance 1965, their transaction is actually a void transaction. So the transaction is actually not allowed under the law. So because of that, the person who wants to use the paddy land, he cannot claim for any breach of contract, but the person, because this contract is considered a void contract, but the person who already get the 1,500, he have to return the 1,500 back to the person who wants to use the paddy land. So in this situation, he does not get any damages because the contract is a void contract, but the other party who has already get the benefit under the void contract, he have to return the benefit to the other party. So that's how right of restitution works. Okay, so similarly in the case of Yip Moy lawan Chiu Chin, in that case, one of the party deposited some money to a person who has a borrowing business. So this person, there is this one person who have a company where this person will hold people's money and he will invest it for some purpose. So one of this person, he deposited some money with that person. So under the law, actually, that person who has the person who actually hold the money actually does not have any license to collect any money from anyone. Okay, so actually he does not have any right to collect money, and he is doing an unlicensed business. So this person who put money in the deposit. So he put the money with that person in good faith, and he also received interest from it. So what happened is that the person who hold the money die. Okay, so when the person who hold the money die, this person who put her money in to that person is worried about the safety of her money. So she wants to get back her money. So she filed a suit against the estate of borrowing company's the borrowing company who had died. So he filed a suit against his estate, and that is when she discovered that the transaction is actually void. So only at that time she come to know that actually that person is carrying an unlicensed business. So that person does not have any right to collect money from her. So what happened to the case? The court held that because because the contract is void, the person who put money inside that business, she is entitled to the restitution of her money. So the business have to return her money back to her under the principle of restitution, because the company has already received advantage from its use. So the company have to return the money. So the right of restitution is when whatever you have to return back, and whatever the other person have, they have to return back to you. So that is the right of restitution. Okay, so for a contract which is a void contract or a contract which is an illegal contract, what will happen to the contract is that the contract will become void, and the person will only get remedies under the right of restitution. So I return back what I have to you, and you return back to me whatever you have. Okay, so before we continue with how to discharge a contract, do you have any question?
Miss,
Yes.
if let's say the one party cannot give back what the another party gives, so what kind of problem he will face?
Because this is under the right of restitution, you have to restore to the other party what you have gained under the contract. So if you cannot give it back, for example, maybe you have used it, or maybe you have sell it to someone else, you have to pay compensation. So you will be ordered by the court to pay compensation to the other party.
So the amount will be the same exact, or the
The court will decide what is the adequate amount in lieu of returning back that thing.
okay, Miss. Thank
Okay.
you.
Okay. Any other question? Any other question? No. Okay. So if you have no question, we will continue with the second part, which is how to discharge a contract. How to put an end to a contract if you don't want to continue with the contract anymore. Okay. Okay, so under the law, there is three ways on how to discharge a contract. There are actually four ways, but one of the way to end of contract, I already discussed it during the last 2 weeks, which is one of the way how to discharge a contract. You can also discharge a contract by agreement. So if both parties agree to end a contract and they sign an agreement, a new agreement which states that the old agreement is has ended, that is also considered one of the way to discharge a contract. So for this class, we will only be discussing on the other three ways on how to discharge a contract, how to put an end to the contract. So the first, so the first way of discharging a contract is by performance. And then you also can discharge a contract by frustration. And the third one is a contract can also be discharged by breach. Okay. So we start off with discharging a contract by frustration. So what does it mean by a frustrated contract? So under Section 57 of the Contract Act 1950, a contract is frustrated when there is a change in the circumstances. So the circumstances is no longer the same as the circumstances where when you sign the contract. There is a change in the circumstances which the promisor could not prevent. So a contract can only be discharged by frustration if the change of circumstances is something which is beyond the control of the promisor. So the thing that happened must be something that the promisor could not prevent, and the change in the circumstances must happen after the contract has been entered into. So what happened is that the circumstances change, and the circumstances and the change is beyond the control of the promisor, and the change happens after the contract has been signed, and the effect of that situation, the effect of that circumstances is the effect of that circumstances is it renders a contract to become impossible or unlawful to perform. So if there is a situation where something happens beyond the control of the promisor after the contract has been signed, and it caused the contract to become impossible or unlawful to perform. So you cannot perform the contract anymore. So the contract will be discharged by frustration. So when we say a contract is impossible or unlawful to perform, it means that the contract cannot be performed anymore. If the contract can be performed but it becomes more difficult, or if the contract can be performed but it will take longer, the contract cannot be discharged by frustration. Okay, so there are certain situations where a contract becomes frustrated. The first one is when when there is a physical impossibility because of the destruction of the subject matter. So this is discussed in the case of Taylor against Caldwell. So in this case, the plaintiff agreed to rent a musical hall from the defendant. So the plaintiff wants to use the musical hall for grand concerts. So the plaintiff wants to hold concerts there, and the plaintiff also wants to hold events there. However, before the performance starts, the music hall was destroyed in a fire. So a fire destroyed the music hall through no fault of either party. So something happened to the musical hall. The musical hall caught fire and it was totally destroyed. And the plaintiff sued for breach of contract because the plaintiff said that defendant should have breached the contract by not providing them with the music hall. So in this case, the court held that the contract was frustrated. So the defendant was released from their obligations under the contract because the contract was frustrated. Because the burned down musical hall, when the musical hall burned down, it renders the contract undoable under the current terms. So because the musical hall has burned down, you no longer have a musical hall, so the contract is frustrated. So because you cannot hold any concert because the musical hall is no longer there. So in this situation, it is considered that the contract is frustrated. So that is for the first example. The subject matter has become disrupted. So it is physically impossible to continue with the contract. The second situation, there is a change in the law rendering performance impossible. So this is the case of Harlock against Beale. So what happened in this case is that this is actually a case of a British ship. This British ship was detained at a German port after a declaration of war between Great Britain and Germany. So the ship is at a wrong place at the wrong time. So when there is a declaration of war between Great Britain and Germany, a British ship at that time was at a German port. So the ship was detained as a hostage at the German port. So the crew of that ship was whole on the ship for a few months, I think 2 to 3 months. And after that period, they were removed from the ship and they were put in prison. So this crew were removed from the ship and they were put in prison. And until the case was taken to the court, no one knows what actually happened to the crew. So in this case, the plaintiff's wife, one of the crew of the ship, she sues the ship owner for wages because the crew of the ship, they entered into a 2-year contract. So the plaintiff's wife sued the ship owner, who is a British citizen, for wages due to her husband under the contract. So the court held that in this situation, the contract had become frustrated because the capture of the ship by the Germans is something beyond the control of the owner of the ship, and it also made the performance of the contract impossible because once the ship was detained at the German port, it can no longer do its works, and the crew can no longer do their works, so the contract is frustrated. So that is for the second situation. For the third situation, the contract becomes frustrated due to impossibility because of non-occurrence of event based into contract. This is discussed in the case of Krell and Henry. So what happened in that case, the defendant agreed to hire from the plaintiff a flat in London on 2 days, for 2 days. So defendant want to hire a flat for 2 days because the defendant wants to watch a coronation procession would take place, and the coronation procession will pass along in front of the flat. So that's why the defendant wants to hire the flat. But when they signed the contract, the defendant paid for the deposit. However, the procession does not take place on the announced dates. So there is no coronation procession. So the defendant has no reason to stay in the flat, and the defendant does not want to pay for the balance of the rent. Okay, so in this case, the court held that both parties knows the court held that both parties recognize that the taking place of the coronation processions is the foundation of the contract. So even though it was not stated in the contract that he wants to hire the flat because he wants to watch the coronation procession, but both parties knows that the reason why the defendant want to hire the flat is because he wants to watch the procession, the coronation procession. But because the coronation procession does not take place, the plaintiff was not entitled to recover the balance of the rent. Because the defendant also, because the coronation does not take place, he does not want to use the flat anymore. So he does not want to use the flat anymore, so he does not want to pay for the balance of the rent. So the court held the contract has been frustrated because the basic of why they signed the contract is no longer there. So the contract is frustrated and the plaintiff is not entitled to recover for the balance of the rent. And then the last situation is where the particular state of affairs cease to exist. In this situation also, a contract will become frustrated. In this case, the case of Coldefa Construction, in this case, the plaintiff agreed to build a tunnel for a railway line for the defendant. So the contract states clearly that the plaintiff have to complete works by certain dates, and he have to complete all works within 130 weeks. So inside their contract, it was stated that the plaintiff will work 3 shifts a day, 7 days a week. But the work was noisy and it caused so much noise, so much vibration, which caused some of the neighbors, some of the people who live around the area to file an injunction. So that person filed an action in the court stating that they file an action in the court for injunction. Injunction we will look later in this topic. Injunction is when you ask the court for an order to ask someone to do something, to compel someone to do something, or to uh, to prevent someone from doing something. So in this case, the injunction was filed to prevent the plaintiff to do their work according to the contract. So the injunction was granted. So according to the order by the court, the plaintiff can only work 6 days a week. So the plaintiff can no longer work 7 days a week, and the plaintiff also have to work only 2 shifts a day, because actually initially in their contract they want to do it throughout the day, the whole day. That's why they have 3 shifts. But the court gave order that they can only do 2 shifts. They cannot do any work at night. So that's what happened. So because they cannot work for 3 shifts a day, they cannot work for 7 days a week. It caused delay in the construction. Okay, so when the construction delayed, so it takes longer time. So it costs more money. So in this situation, the plaintiff claimed the additional sums from the defendant, because they said that they have to suffer some additional costs, and they have to suffer some loss of profits, because they cannot work 24 hours 7 days a week as already agreed in their contract. But in this case, the defendant refused to pay. So the people who built the tunnels claim for more money, because they said due to the injunction they cannot work as agreed. So they want more money to cover all the additional costs. So the defendant refused to pay. So the defendant said that this is a breach of contract, because we agreed to do the works for 3 shifts a day, 7 days a week, and you have to finish it by 130 weeks. Because you fail to do so, it is a breach of contract. So the court held that in this case, there is no breach of contract, but the contract is actually frustrated by the injunction, because the injunction is something which is filed by a person who is not party to the contract, and the order of the court is something out of the control of the plaintiff and the defendant. So because of that, the contract is frustrated by the injunction. So the plaintiff is entitled to claim for the additional sums. Okay, so from all these cases, we can see that a contract is only frustrated. So a contract only becomes frustrated if the events that happen is something which is out of the control of both parties. So both parties cannot do anything about it. Both parties have no part in it. So both party is not at fault. What happened is something which is out of their control. So in this kind of situation, a contract can be discharged by frustration. Okay, so that is the first way how to discharge a contract. So what happened when a contract is frustrated? So when a contract is frustrated, it discharges the contract immediately from the time of the frustrating events. So once a contract is frustrated, the contract comes to an end. But whatever obligations arise before the frustrating events must still be fulfilled. Okay, so for example, we use the example of that case of the railway station. If before, for example, in this case of Coldefa Construction, if before the injunction was ordered, the plaintiff already did some wrong. So even before the injunction was granted, the plaintiff only works 6 days a week, or the plaintiff only do 2 shifts a day. In that situation, the defendant can claim any damages under the breach of contract. But if the plaintiff only, the people who built the tunnel only do 2 shifts a day, only do work 6 days a week after the injunction was granted, at that time the contract is already frustrated. So when the contract is already frustrated, you cannot claim for breach of contract, but any obligation arise before the frustrating event, it still must be fulfilled. Okay, so for a frustrated contract, what can you get? The remedies that you can get for frustrated contract is the same as is the same as a contract which is a void contract. Okay, so even for a contract which is frustrated, the right of restitution still applies. So whatever you have gained under the contract before the frustrating event, you have to return. Whatever you have gained after the contract has been frustrated, you have to return, and any other things the other party have received before after the frustrating event, you also have to return it. So the remedies for a contract which is frustrated is similar to a contract which is void. So they also have the right of restitution. Okay, so that is the first way on how to discharge a contract. Do you have any question on a contract discharged by frustration? No question. Okay, so if there is no question, the second way on how to discharge a contract is discharge by performance. So this is the simplest way, the easiest way. Under Section 38 of the Contracts Act, it states that a contract must be performed exactly, precisely, and in accordance with what the parties has promised. So if a contract was performed exactly as what you had promised, if a contract has been performed precisely as what has been promised between the parties, and the contract has been performed in accordance with what the parties had promised, the contract is said to be discharged by performance. Okay, so under Section 38 and Subsection 1 of the Contracts Act, parties to a contract must either perform or offer to perform their respective promises unless such performance has been dispensed by any law. Okay, so a contract can be discharged by performance from a third party and not necessarily from the promisor. So just like a consideration which can come from a third party, performance of a contract can also come from a third party. It does not matter if the contract is performed by the parties to the contract or if it is performed by a third party, unless there is a term in the contract which specifies that the contract requires personal performance. Okay, so as a general rule, in normal situation, performance can come from a third party. It does not matter if the contract is performed by the parties to the contract or by a third party. But if if there is a term in the contract which states that the contract should be performed by the promisor himself. So if there is any terms in the contract stating that the contract must be performed by yourself. You cannot hire anyone else to do it on your behalf. You cannot ask anyone else to do it for you. So if the contract states that the contract must be performed by the promisor himself, the contract can only be discharged by performance if it is performed by the promisor himself. So this is what happened in the case of Lachli Amal. Okay. And section 39 also states that if a promisor has made an offer of performance to the promisee and the offer is not accepted, so the promisor has offered to give you something, has offered to perform his part of the contract, but you don't want the contract to be performed, the offer is not accepted, the promisor is not responsible for non-performance, and he does not lose his rights under the contract. So that's why In section 38, it states that parties to a contract must either perform or offer to perform. So what is the example of situation when someone offer to perform a contract? You can look for the example in the illustration in under section 39. So under the illustration, it states that A contracts to deliver to B at his warehouse on the 1st March 100 bales of cotton of a particular quality. So if someone has signed a contract to deliver to you on a certain date, something of a particular quality. So you have put on in details when it must be performed, how it must be performed, how much you must give. So in order to make an offer of performance with the effect stated in this section, A must bring the cotton to B's warehouse on the appointed day under such circumstances that B may have a reasonable opportunity of satisfying himself that the thing offered is cotton of the quality contracted for and that there are 100 bales. So if one of the party had followed the contract to the T, I mean the one of the parties has followed exactly everything agreed upon under the contract, and they offer to perform their part of the contract. But you, as the other party, you don't want to accept the performance. In that situation, if they can prove that they had fulfilled all the things agreed in the contract, that person is not responsible for non-performance. And you cannot later claim for breach of contract because that person has offered to perform their part of the contract. It's you who refuse to accept the performance. That is what discussed that is what is section 39 all about. Okay, and then there is also a case of Haji Nik Ishaq lawan Nik Zainab. In that case, it states that if a promisee accepts performance from third party, they cannot afterwards enforce it against the promisor. Because performance of a contract does not have to be from the promisor unless it was stated clearly in the contract. If you have accept performance from a third party, you cannot afterwards enforce it against the promisor because the contract is considered to have ended due to performance. Okay, so that is the second way how to perform a contract. Okay, so before we go to the last way how to discharge a contract, do you have any question on discharging a contract by performance? No question. Okay, so if there is no question, we will look at the last type of ways to discharge a contract. The third one is discharge by breach. Okay, so when one of the parties to a contract fails to perform their obligation as agreed in the contract, they are in breach of contract. So a breach of contract happens when one of the party fails to perform the obligations as agreed in the contract. So breach can occur in many ways, including failure to comply with the terms of the contract. So if you fail to comply with any of the terms of the contract, it is considered a breach of contract. Or if one of the party to the contract announce that they are no longer interested in carrying out the obligations under the contract, a contract is also is discharged by breach. Or if there is delay in the performance where time is of the essence of the contract. So if the contract clearly states that the contract must be performed at a certain date at a certain time. So if there is a delay in the performance, you do not show up on the agreed date, you do not show up at the agreed time, it is also considered a breach of contract. And then a breach can also be an anticipatory breach. So what it means by an anticipatory breach is, in this case of Hochster against De La Tour, in this case, the defendant agreed to employ the plaintiff as a courier to work as a dispatch for the defendant. So the plaintiff have to start work on 1st June. So the contract, they already signed a contract, and the contract states that the plaintiff will start work on 1st June. However, on 11th May, the defendant wrote a letter to the plaintiff informing him that his service were no longer required. So the plaintiff immediately sued for breach of contract without waiting for the 1st June to happen. So the court held that the plaintiff could bring an action as soon as he was aware the defendant intended to breach the contract. He need not wait until the contract was actually breached. So this is what we call an anticipatory breach. Similarly, if you have, for example, you have a contract for, you have a contract with someone else, and the contract is for 2 years. For example, the contract is supposed to be a 2 years contract. And then after the first year of the contract, the other party tells you that I no longer wants to do contract with you. Even though the 2 years have not lapsed, you can take action immediately against the other party for anticipatory breach. Okay, so anticipatory breach is the situation when you know that that person have no intention to continue to do the obligation under the contract. The other party intends to breach the contract. Even though the due date has not come, you can immediately sue them. Okay, so that is anticipatory breach. So what happens when a contract is breached? Under Section 40 of the Contracts Act 1950, when a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the innocent party may put an end to the contract. So what happens when a contract is breached? One, you can put an end to the contract. You can end the contract, but the innocent party may also acquiesce in its continuance. So if the breach of contract is something very serious, for example, a breach of the condition of the contract, so you can choose either to end the contract, or you may also acquiesce in its continuance. You can also agree to continue the contract. However, if it is a breach of a less important term, which is a warranty, the innocent party is still going to have to carry out the obligation and sue for damages. Okay, so for example, a breach of contract is, I think there is instruction first. Yeah, if you look in the illustrations under Section 40 of the Contracts Act, in situation A, a singer enters into a contract with B, the manager of a theatre, to sing at his theatre 2 nights in every week during the next 2 months. So if a singer enters into a contract to sing for 2 weeks every week for 2 months, and B agreed to pay 100 for each night's performance. However, after 6 days, the 6th night, A willfully absents herself from the theatre. So on the 6th day, the singer does not want to perform. So in that situation, it can be said that the contract has been breached, and the manager of the theatre is at liberty to put an end to the contract. So he can cancel the contract. He can put an end to the contract for breach. However, if you look at the situation B, on the 6th day, the singer does not come. But on the 7th day, when the singer comes back, the manager allow him to continue. The manager allow him to continue to sing at the theatre. That is what we call acquiescence in its continuance. Okay, so because the C assents for A to continue singing on the 7th night, so B has signified his acquiescence in the continuance of the contract and cannot now put an end to it, but is entitled to compensation for the damage sustained by him through A's failure to sing on the 6th night. So if something happened, someone has breached the contract, and you still wants to continue with the contract, you can continue with the contract, and you can also claim for damages. So if one of the parties breach the contract, the innocent party can choose either to put an end to the contract, or they can acquiesce to its continuance. You can allow the other party to continue with the contract, and you claim for damages. That is for breach of condition. But if it is a breach of a warranty, something which is less important, you cannot end the contract, but you can sue for damages. That is for breach of contract. Okay, so before we continue with the remedies, which is allowed under the under the law, do you have any question on discharge of contract by breach? Everyone is clear on how to discharge a contract? Okay. So if you have no question, we'll continue to the last part of law of contract, which is remedies. So if a contract is discharged, if a contract is found to be a void contract, if a contract is a voidable contract, if a contract is frustrated, what are the remedies allowed under the law? So under the law, there are 5 types of remedies for a contract. The first one is rescission. The second one is restitution. The third one is damages. Fourth one is specific performance. And the last one is injunction. So what is rescission? Rescission allows an innocent party to cancel the contract by rescinding the contract. So rescission is when you are allowed to cancel a contract. So what is the purpose of rescission? Is to reverse the contract and restore the parties as near as practicable to their original pre-contractual positions. Okay, so a rescission is when a contract is cancelled. So a contract can only be rescinded in 2 situations. First one is when the contract is voidable under sections 19 and section 20 of the Contracts Act. So if a contract is entered into without free consent, if a contract is entered into by coercion, fraud or misrepresentation, or if a contract is entered into induced by undue influence, this kind of contract can be cancelled. So the contract can be rescinded. Okay, so when a contract is rescinded, it will reverse the contract and restore the parties as near as practicable to their original pre-contractual position. So there is also another situation where you can cancel a contract. You can also cancel a contract in cases of breach of contract. So when there is a breach of contract, the innocent party has the right of election, either to rescind the contract or affirm the contract. So if you rescind the contract, you will put an end to the contract, or you can affirm the contract and claim for damages. So once a contract is rescinded, once a contract is cancelled, Section 65 of the Contracts Act come into effect. So once a contract is cancelled, the promisor need not perform his part of the contract. So the person who is the innocent party need not perform his part of the contract. But if he has received any benefit under the contract, he must restore the benefit to the person from whom it was received. Okay, so this is for rescission. The second one, restitution. Restitution is sometimes referred to as quasi-contract. It is not contractual and does not rely on the plaintiff suffering loss or damage. So restitution is based on the principle of unjust enrichment, because the situation shows that it would be unfair if the defendant was to be allowed to retain the money or the goods or service without payment. So for the damages of restitution is when someone has received any benefit under the contract and something happened to the contract. So to avoid from any of the parties having unjust enrichment, both parties have to pay whatever they have received under the law, under the contract. So that is the principle of restitution. So the third one, which is the most popular type of remedies, is damages. Damages is monetary compensation. You get money as damages from breach of contract. So the main purpose of damages is to enable the innocent party to receive monetary compensation from the party responsible for the breach of contract. So damages is usually granted for breach of contract. So it was not awarded to punish the wrongdoer, but it is to put the injured party back in the position that they would have occupied if the contract had been performed as originally intended. So it is not awarded to punish the wrongdoer, and it is not awarded to give unjust enrichment to the innocent party, but it's only the purpose of damages is to put the injured party back in the position that you have occupied if the contract has been performed. So if there is no breach, what are they supposed to get? Actually, what are they actually supposed to get under the contract? That is what damages will will award to you. So the court will consider if the contract has not been breached, if the contract has been performed as originally intended, if both parties have performed their part of the contract, what will both parties get? So that is how the court will see how much damages to award to the innocent party in the contract. So it is granted as compensation for damage, loss, and injury that the plaintiff has suffered through the breach of contract. Okay, so that is the purpose of granting damages for breach of contract. Okay, so under Section 74 of the Contracts Act, when a contract has been broken, the party who suffers is entitled to receive compensation for any loss or damage which naturally arose in the usual course of things. So, if the damage is something which naturally arose in the usual course of things, or damage which the parties knew to be likely to result from the breach, all those damages can be claimed. So that is the type of compensation that can be received by a party to a contract. Okay, so for example, if you want to hire someone if you want to hire someone to provide food for your party. For example, you are conducting a party, and then you want to hire someone to do catering for your party, to provide food and service for your party. And the other person breached the contract by not providing the service and the food as promised. What type of loss will you suffer in that situation? You want to do a party, so you hire a company, a catering company, to provide food and service for the event, and the person breached their contract. They don't provide any food or services for your event. What type of loss can you claim from them? Anyone? As the plaintiff in this case, what type of damages do you think you can claim?
Money maybe, madam?
Money for what?
For the payment that we pay for the catering.
Okay, for the money that you have to pay for the catering, and then what else? So first, maybe you will claim deposit paid to caterer. What else can you claim? Because under Section 74, it states that you can claim a compensation for anything which naturally arose in the usual course of things, or anything which the parties knew to be likely as to result from the breach. What else you can claim? You can claim the deposit. What else?
The food for free.
The food. We cannot say the food for free because they don't provide the food. Maybe you can claim for costs of hiring another caterer. First, you can claim for the deposit you already paid to the caterer. And then you can claim for cost of hiring another caterer. And then what else? What else can you claim? Transportation money. Transportation money for apa ya?
Maybe they are traveling. Some people would have traveled from far, right? So they can get money from that.
Your cost of, yeah, because you
Travelling
have
far.
to do damage control, your transportation.
Yes.
Yeah. Okay, so under the law, it states that you can claim anything. You can claim anything as long as it is something which naturally arose in the course of things. So it's normal that when you breach your contract, the other party will suffer some loss because they have to hire another caterer. They have to call last minute to the other caterers. Maybe the other caterers, yes, cost of the party. Maybe the other caterer is charging more. Or maybe you have hired this caterer because you want some kind of special dish which can only be cooked by the chef who works with this caterer. But because the caterer cannot provide the food, you have to hire from other caterer. You cannot get that food you want. That also you can claim because that is everything we say which is the naturally arose in the usual course of things. So all the normal costs you have to incur because of the breach of contract and all the things that you have to suffer because of the breach of contract, all of that you can claim. Okay, so you can claim anything under Section 74. The exception is only the damage cannot be too remote or indirect. So if the damage is something which does not have anything to do with the breach of contract, you cannot claim for that. But if the things that you have suffered, the loss that you have suffered has anything to do with the breach of the contract, you can claim for it under Section 74. Okay, and then what you can claim loss of profit arising out of the breach. For example, if you have hired someone for example, you are a designer and you have designed some clothes and you have hired someone to sew the clothes for you, and that person failed to deliver their items to you on the date as promised. So maybe because of that, you have lost some profit because instead of starting selling the products by this week, you have to start selling the product next week because the item was delivered late to you. You can also claim for that loss of profit arising out of the breach. You can also claim other expenses incurred as a result of the breach. So if you have to incur any extra costs, for example, in this in the case of the caterer, maybe if because this caterer fails to provide the food and services, you have to hire another caterer who costs more, or you have to change the venue of your party from a cheaper place to a more expensive place. All that things can be claimed, and you also can claim difference between the price of goods as contracted for and the actual price of goods sold as a result of the breach. So for example, maybe if someone sell you something which is not of a good quality. For example, you have a contract that you want um, to buy some fruit of good quality, but the other party breached the contract by selling you a food with inferior quality, something which the quality is lesser than what you have contracted for. You can also claim for the difference between the price of goods. So you can claim, in short, you can claim anything as long as it naturally arose in the usual course of things and the parties knew to be likely to result from the breach. So if it is something normal, something usual, under the contract, both parties knows if they breach the contract, this thing will happen, you can claim for all that. Okay, and then under section 75 of the Contracts Act, it states that when a contract has been broken and a sum is named in the contract as the amount to be paid in case of such breach, or there is a clause regarding penalty. So if you sign a contract and the contract has a penalty clause, if you breach the contract, you have to pay 20,000 ringgit. Or the contract states that if there is a breach of contract, a penalty of 5,000 ringgit will be due. So the party complaining of the breach is entitled to receive reasonable compensation not exceeding the sum named or the penalty stipulated for. So if the contract has stated that if the contract is breached, you can receive 10,000, you cannot claim for more than 10,000. Or if the contract states that in the case of breach, the other party will be penalized for 5,000 ringgit, you can only claim not more than 5,000 ringgit. But the law still requires you to prove the actual damage suffered. So you cannot just rely on the clause stating that under this clause I can claim 10,000. You still have to prove, do you actually suffer up to 10,000 ringgit? This is stated in the case of Warren Brothers M Limited against Jackson. And then section 75 contract also states that the party seeking damages is also under a duty to mitigate the loss. So you also have a duty to try to reduce the amount of loss you have suffered. If you do not do anything to reduce your loss, if you do not do anything to mitigate your loss, the mitigation of loss will be a factor in how much damages you will get from the other party. Okay, so that is for section 74 and section 75, which is on damages. So next, we will look on specific performance. So specific performance is remedies which is granted under the Specific Relief Act. I'm not sure which year is it. Wait, Specific Relief Act 1942. Specific Relief Act 1950. So a specific performance is a discretionary order granted by the court directing a person to carry out their obligations under the contract. So under specific performance, a court can give any order directing any person to carry out the obligations under the contract. So a specific performance will only be granted for breach of contract if damages is inadequate. For example, under the Specific Relief Act, there is a clause stating that contracts involving land or where the subject matter is unique, like a rare artwork, damages is not adequate. So if damages is not adequate, if money is not adequate, the court can order a specific performance. For example, a specific performance may be granted for agreement relating to land transactions, because there is a presumption that the breach of contract cannot be adequately compensated by money. So usually in land transaction, money is not enough to sufficiently compensate the other party. So the court may order for specific performance. So there are certain situations where you cannot get any specific performance. You cannot get any specific performance if the granting of it would cause undue hardship to the defendant. If the court give you some order and the order will cause too much hardship to the defendant, the court will not grant that. Also, if in that case, the damages is an adequate remedy, giving you compensation in the form of money is enough, no specific performance will be granted. If the terms of the contract is uncertain, no specific performance will be granted. If there has been delay in bringing the action, if you have not taken your action immediately, you have taken your time, you have been delayed in bringing the action, the court may also not grant any specific performance. Or if there is any evidence of fraud or if the granting of it requires constant supervision of the court, or if the contract is for personal service. So in situations where these circumstances happen, the court will usually not order any specific performance. The court will only give damages in that situation. And then the last one is injunction. Injunction is also a court order. So an injunction is a court order restraining a party from breaking their contract or from committing a wrongful act. So injunction, there are three types. Prohibitory. So a prohibitory injunction is an injunction requiring a party to refrain from doing a specific act. So like in the case of Coldefa, it is a prohibitory injunction. So injunction is prohibiting someone to do something. And then there is also a mandatory injunction. A mandatory injunction is an injunction requiring a person to perform some contractual obligation. So when you have a mandatory injunction, you are ordering someone to do something. So you are ordering someone to continue doing something. So that is a mandatory injunction. And then you also have interlocutory injunction. So interlocutory injunction is the type of injunction which is given temporarily until the dispute can be heard by the court. For example, interlocutory injunction is in cases of child custody. For example, when you have a child custody case, one of the party may apply for interlocutory order to get to have the child with the mother until the case is heard by the court. So that is interlocutory. So interlocutory is an injunction which is given temporarily. Okay, so that's all for the types of remedies. Do you have any question? If there is no question, that's all for topic 6. We will have a 10 minutes break before we continue with topic 7. Okay, so if you don't have any question, we'll have a break for 10 minutes. And then around 10:40, we will start with topic 7. Thank
Okay, Miss.
Okay, Assalamualaikum and a very good morning. Okay, so for topic 7, we will look into a different parts in Contract Acts. So this law of agency is also provided under the Contracts Act. So we'll look into the law of agency. And what we will be learning today is we will learn about the definition of agency. What is an agency? What are the types of agency? And then we will also look at the type of contract that you have in an agency. And we will also look at how to create an agency. What are the duties of a principal? What are the duties of an agent? And lastly, we will look at how an agency can be terminated. Okay, so as I explained at the beginning of the class, agency is a relationship where you have two parties, whereby one of the party who is a principal and the other party is the agent. So what this agent do is the agent will act on behalf of the principal, or the agent will be representing the principal in signing a legal contract with a third party. So agency is a word used in law to imply an authority or capacity in one person, who is the agent, to create legal relationship between a person occupying the position of the principal and third parties. Because if you still remember the principle of the privity of contract, under the privity of contract, only parties to the contract can sign a contract, and a third party that does not have anything to do with the contract. But in this law of agency, you are essentially giving authority to someone else, or you are allowing someone else to act on behalf of you, and whatever that person has signed on behalf of you is binding on you and the third parties, because this person is only the agent. You are the principal, so you are the person who is in the contract. This agent is only acting on behalf of you. Okay, so the law of agency in Malaysia is mainly found in Part 10, which is sections 135 until section 191 of the Contracts Act 1950. So who is an agent? An agent is a person employed to do any act for another or to represent another in dealings with third persons. A principal is a person for whom such act is done or who is so represented. So this agent is usually, in many situations you can have an agent, but usually agent is appointed by a person who does not want to do dealings with third parties by themselves. So usually, for example, you are the CEO of your company. When you are doing any dealings, maybe you don't want to do the dealings by yourself. All the small dealings, you will allow all maybe your managers or maybe your assistant to do the dealings for you. So that assistant, that manager is your agent. You are the principal because the act is done on your for your interest. So you are the principal for whom such act is done. So the act is done for your interest. So the one who will get the profit is you. The one who will suffer loss is you. So the one who will be represented is you by the agent. Okay, so in an agency, there are two types of contract. The first one is there is a contract between the principal and the agent. So first, there must be a contract between the principal and the agent, because this is where the agent get his authority. If there is no contract, if there is no agreement between the principal and the agent has no authority. So when the agent has no authority, he has no right to act on behalf of the principal. So first, you must have a contract between the principal and the agent, where the agent gets his authority from the principal. And then there will also have a second contract. So the second contract will be made through the agent between the principal and the third party. So the agent is only the person who represents the principal, but the contract is still between the principal and the third party. So that is the contracts that we have in an agency. So there are 5 types of agent. We have a broker, we have a factor, we have a commission agent, we have a del credere. I'm not sure how to pronounce it. Maybe del credere, I don't know. And the last one is power of attorney. So who is a broker? A broker is an agent who is engaged to make contracts between two principals in trade, commerce, or navigation. So usually if in a trade or in a commerce or navigation, you will have a broker. So a broker is an agent who is engaged to make contract between two principals. Okay, so a broker is usually used to negotiate contracts of sale and purchase. The broker usually is just an agent to the principal. He does not have much power, so that is a broker. And then a factor is an agent who has more extensive power to act for a principal than a broker. So if a broker, he is only allowed to negotiate for sales and sales of a contract of sales, but he does not obtain the possessions of goods from the principal. So the principal does not give the item to him. He just negotiate on behalf of the principal. That is a broker. But a factor is someone who is entrusted with possession of goods. So the principal will give the goods to the factor to sell it. And the factor will sell the goods in the name of the agent. So usually a factor will sell the goods in the name of the agent without disclosing the name or existence of the principal. So if you are a broker, usually the contract will be between the principal and the third party. But if you are a factor, usually the contract will be between the factor and the third party, even though the property actually belongs to the principal. So the principal's name is not in the contract. And then we also have a commission agent. A commission agent who is appointed to sell goods or to buy goods on behalf of the principal. So if you are appointed to buy or sell goods on behalf of the principal, you are a commission agent. And then if you are a del creditor agent, you have an added duty to ensure the principal is paid by the third party. So if you are a commission agent, you have to sell and buy on behalf of the principal. But if you are del creditor, you have an added duty. You have to ensure the principal is paid by the third party. So that is also your work, to ensure that the principal is paid by the third party. And then the last one, which is the most common one, is the power of attorney. So power of attorney is a legal instrument. So among all these 5 types of agent, the power of attorney is the clearest one, which is a legal instrument, under which the principals give authority to the agent to perform certain acts for the principal. So for example, in Malaysia, one of the transactions where we will have this power of attorney is when you have a housing transaction, sale and purchase of house transaction. When you take out a loan, at that time you will you will sign this document of power of attorney. So the power of attorney will give power to the agent of the principal to do certain works on behalf of the principal. So that is the power of attorney. So the power of attorney, unlike other types of agent, the power of attorney is governed by the law. There is a statute for a power of attorney, which is the Powers of Attorney Act 1949. And this power of attorney is usually registered in the High Court. So among all types of agent, the 5th one, the power of attorney, is the one which is most used, and it is also the one which is most formalized, and it is also the type of agent which is governed by an act. Okay, so that is the 5 types of agent. So who can be a principal? A principal, as I mentioned before, is the person who is represented by someone else to do a transaction. So, because a principal will usually be part of the parties to the contract, Section 136 of the Contracts Act states that anyone who is above 18 years old and is of sound mind can be a principal. So if you want to be a principal, you must have the capacity to a contract. You must have the capacity to enter into a contract, which means that you have to be above 18 years old. You must be more than 18 years old. And you also must be a person of sound mind. You cannot be a person who is unsound. So if you want to be a principal, you have to have the ability to enter into a contract. But if you want to become an agent, there is no requirement that an agent must be above 18 years old. And there is also no requirement that an agent must be of sound mind. It means that you can appoint someone below the age of 18, and you also can appoint someone who is of unsound mind to be a principal. But the person of unsound mind and those who are below 18 years old, they are not liable towards the principals for acts done by them as agents. For example, if A employs B, who is a minor, to buy some goods from C on his behalf. Okay, so the contract will be between A and C. B is only acting as an agent of A. So when B has negotiated on the contract with the C, C supplies the goods. So when C supplies the good, when C has performed his part of the contract, A is still liable to pay for the goods, even though A's agent is still a minor. So even though the agent is a minor, it does not excuse the principal from their liability. Even though the agent is a minor, once the agent has entered into a contract with a third party on behalf of the principal still have to be liable to perform his part of the contract, even though his agent is a minor. But if you look at section 136, there's no here. If in the situation C, who is a minor, did something wrong to the principal, maybe C used A's property for his own benefit, A cannot take any action against C because his contract with C is not a valid contract because C is a minor. So if we refer back to this part, there are 2 contracts in an agency. So the first contract is the contract between the principal and the agent, and the second contract is between the principal and the third party. So if the agent is a minor, the second contract is still applicable, is still enforceable, but the first contract is not enforceable because the minor is not does not have the capacity to enter into a contract. So that's the only risk of having a minor or person of unsound mind to be your agent. Okay, so that is the principle of who can be a principal and who can be an agent. Okay, so before we continue with the creation of an agency, do you have any question on who is an agency? What type of relationship does an agency have with their an agent have with their principal? Do you have any question on the nature of agency? No question.
Miss, I have.
Yes. Mm-hmm.
Just now the madam said about the first contract and the second contract, right? At the box, the chart. So means the second contract, it means the agent does not have the authority or what?
Are you talking about the if the agent is a minor?
No, because it said like between principal and third party made through the agent, but
Yeah.
at the first contract it said like it's derive the authority. So I'm not clear at that.
Okay, so in an agency there are 2 types of contract. So the first contract is the contract between the principal and agent. So in this contract, the principal give the authority to the agent to act on his behalf. And then when the agent got the authority from the principal to act on his behalf, the person who will negotiate with the third party is the agent. So the second contract will be made by the agent with the third party. But the contract is usually still between the principal and the third party. So the name in the contract is the principal and the third party, but the contract is actually negotiated between the agent and the third party.
Oh, okay, madam.
Ah.
I understand.
Okay.
All right.
So that is the purpose of agency, because you don't want to do the dealings by yourself. You hire someone else to become your agent. So that person will negotiate on your behalf, and that person will sign on your behalf. Sometimes they sign on your behalf. So, but the agreement is still between you and the third party. Okay. So, any other question? Okay, so if there is no other question, we'll look on how to create an agency. Okay, so an agency, a contract of agency can be expressed or implied, which is normal as in a normal contract. It can be an express contract, or it can be an implied contract from the circumstances and conduct of the parties. So the authority of an agent may be expressed. So if the authority is given by words spoken clearly, explicitly, or the contract is in written. So if it is in written, it is what we call an express contract of agency. But if it is not explicitly spoken or it is not in written, it will be implied contract of agency, which is inferred from the things spoken or written or from the ordinary course of dealings. So if it is not clear, you have to look whether this contract of agency is an implied contract of agency. So in this case of KGN Jaya Sendirian Berhad against Pen Reliance, the court held that agency arrangement need not be in writing. So an agency arrangement can be in writing and it can be oral only. And section 138 also states that no consideration is necessary to create an agency. Under the law, if you become an agent for someone else, there is no requirement that you must be paid. We'll look at further down on the later slides. There is this situation we call gratuitous agency, I think. But it is a situation where you become an agent for the principal, but the principal does not pay anything to you. So you just become the principal for the you just become the agent for the principal on goodwill. So that is why under section 138, it was stated that no consideration is necessary to create an agency. So you need not pay your agent to do things for you. Okay, so how to appoint an agent? There are 1, 2, 3, 4, 5, 6. There are 5 ways to appoint an agent. An agent can be appointed by in 5 situations. So the first situation is by express appointment. So when you expressly appoint someone, orally or in writing, when you there involve actual consents between the principal and the agent. So both the principal and the agent knows that the principal is appointing him as his agent, and the principal know that the agent is acting on behalf of the principal. So it will be a creation of agency by express appointment. So the express appointment can be in written or oral form. So if it is in written, it can be like the power of attorney, which is a legal document, or it can also be in a form of letter or any type of written item. So as long as it is in written or it is in oral form, expressly, explicitly, it is what we call a creation of agency by express appointment. The second one, an agency can also be created by implied appointment. By implied appointment is when you got the agency got the authority by way of implied consent of the principal and the agent. So there is no written contract, there is no oral explicit contract, but the authority is by way of implied consent. So the law can infer the creation of agency by implication when a person by his conducts or his words holds out another person as having authority to act for him. So if someone stated but not very clearly that or if someone by conduct shows that he is appointing another person as his agent, the agent can be created by implied appointment. Okay, so it is not clear. If it is clear, it will be by express employment. But if it is not clear, the person maybe say some vague words, or the person may imply by his conduct. It will be the agency will be created by implied appointment. And then the third way of creating an agency is by usual authority. So by usual authority means that the agency is created by the agent occupying a position which would normally carry with it authority to do the act in question. The case, for example, in this situation is the case of what you versus Fenwick. In this case, the case is actually about an agent who has the wait, okay, so in this case, actually, the plaintiff, which is this Mr. Watt, I'm not sure how to pronounce his name, he supplies cigar to a beer house. So he works as a supplier of cigar to a beer house named Victoria. So the beer house was operated by a man named Humble. Okay, so the person who operate the beer house is Mr. Humble. So before this, Mr. Humble was doing the business by his own, but there is this 1 year that Mr. Humble has assigned his interest to the defendant. So there is this one. So the original owner of the Victoria is Mr. Humble, but there is this one time that Mr. Humble has transferred his right to a different person named Fenwick. So actually the owner of the Victoria has changed from Mr. Humble to Fenwick. Okay, but even though he has assigned his right to Fenwick, so even though the owner of that house, that beer house is actually Fenwick, Mr. Humble remained as the manager of the beer house. So Mr. Humble continued to operate the business as usual. So the business is operate as usual by the same person, only the owner has changed. Okay, so when he is signing anything, he is still signing in his name, and the license will also held in his name. Okay, so the plaintiff supplies cigars to Humble, and the plaintiff does not have any idea that actually the owner of the beer house has changed from Humble to Fenwick. So even though one situation happened, a problem occurs when Humble failed to pay for the supply of cigar to the plaintiff. So the plaintiff claimed for the price of the cigar that they have supplied. So the court held that in this situation, even though Fenwick is in this situation, as Fenwick has taken the rights of the shop, because Mr. Humble has transferred the ownership of the beer house to Mr. Fenwick. So because Fenwick allows Mr. Humble to continue operating the beer house, it is said that Fenwick has appointed Mr. Humble to be his agent. So even though in this situation, Fenwick did not say anything about appointing Mr. Humble as his agent, but because Fenwick has allowed Mr. Humble to continue operating the beer house as usual, so the court held that an agency has been created by usual authority. So because Mr. Fenwick did not say anything about Mr. Humble operating the beer house, it is said that he has appointed Mr. Humble as his agent by usual authority. And Mr. Humble can do anything which would normally be carried out by him as an operator of the beer house. So that is the third way of creating an agency. So in this situation, for example, if you buy a shop from someone else and you did not say anything about the workers in that shop and you did not clarify about who will be operating the shop now, whether the workers will still be working for you or not, who will be signing everything for the contract. If you did not specify, there will be an agency will be created by usual authority. So if that worker do anything on your behalf because you have not informed him of the change of situation, if the worker did what he is doing as usual and something happened, you will still be liable because you have created an agency by usual authority. Okay, so that is the third way of creating an agency. And then there is the fourth way of creating an agency is by ratification. So ratification arises in any of the following situations. For example, an agent who was duly appointed but has exceeded his authority, or a person who has no authority to act for the principal but has acted as if he has the authority. So that is an agency which is created by ratification. So when an agency is created by ratification, under Section 149 of the Contracts Act 1950, if any of the situation mentioned arise, so if the situation where an agent who was duly appointed but has exceeded his authority, or if the situation where a person who has no authority to act for you, for the principal, but has acted as if he has the authority, if these two situations happen, Section 149 states that the principal can either reject the contract or accept the contract so made. So if someone has acted on your behalf without your permission, or if someone has acted on your behalf exceeding the authority, for example, you only allow them to buy the product if it costs not more than 40,000 ringgit, but that person has signed the contract even though the contract is for 50,000 ringgit. So that is a situation where your agent has exceeded his authority. So if this situation happen, as a principal, you can either reject the contract or accept the contract. So if you accept and confirms the contract, so you accept the contract even though it is made not as per your permission, or it is made by someone who is not given permission by you to make the transaction, the acceptance is called ratification. So an agency can also be created after the transaction has happened. So when the transaction has happened and you accept and confirms the transaction, you confirm the contract, your agency is created after the transaction has happened and is called ratification. So ratification may be expressed or implied under Section 150. So what happens if you have ratified a contract? If you have ratified an agent, it renders the contract as binding on the principal as if the agent has been properly authorized beforehand. Okay, so for example, you have a house. You have a house and you want to sell the house. But actually, you did not give any authority to your wife to sell the house on your behalf. You did not give any authority, only either expressly or impliedly. You did not give any authority to your wife to sell the house, but your wife has acted as your agent without your consent or your permission, and your wife has agreed to sell your house to somebody at a certain price, for example. And then when you come to know about it, what you can do is you can either reject the contract. If you don't want to honor the contract made by your wife, you can reject the contract, or you can choose to accept the contract. So maybe when you read the terms of the contract, you think that this contract is beneficial to you. You will get profit from this contract. So you can choose to belatedly created the agency, belatedly appoint your wife as your agent by ratification. Okay, so once you have ratified the creation of agent, so the contract will be binding on the principal. So even though when your wife signed the contract, she does not get any permission to act on your behalf, but because you have ratified her appointment as an agent, the contract will be binding on you, as if you had appointed your wife before she goes and negotiate on the house. Okay, so a contract can only be ratified in certain circumstances. First one, the act or contract must be unauthorized. Like in the situation where I said the wife is negotiating about the sale of a house without the permission of her husband. So the act of the wife must be an unauthorized act. So the husband must not give any permission to the wife beforehand to negotiate on his behalf. And then the second condition is the agent must at the time of the contract expressly act as agent for the principal. So the third party must know at the time that the person who she or he is negotiating with is not the owner of the property. He is not the principal. And then the third condition is the agent must have a principal. So when an agent is acting on behalf of a principal, the principal must exist. There must be someone who is the principal, and you must know who is the principal. And the principal must have contractual capacity at the time when the contract is being made and at the time of ratification. So for a contract to be ratified, for an agent to be appointed after the dealings had happened, the principal must have contractual capacity at the time when the contract is being made. So when the contract was made, the principal must be above 18 and he must also be of sound mind. And when the contract is ratified, also the principal must be above 18 and the principal must also be of sound mind. So for example, if the principal is of sound mind when the contract was made, but when the contract was ratified, for some reason the principal become of unsound mind. Maybe he suffered from Alzheimer or whatever type of condition which affects his mental capacity. The contract of agency cannot be ratified. Okay, and then the principal must have full knowledge of all material facts at the time of ratification. So if it comes back to the situation where the wife signed a contract to sell her husband's house without her husband's permission, so if the husband want to ratify the contract, want to ratify the agency, want to ratify his wife as his agent, he must have full knowledge of all material facts at the time of ratification. He must know everything about what the contract is about, how much is the house is being sold, how is it going to be transferred, how long will it take for him to get money. He must have full knowledge of all the facts. Unless he said that I don't care what are the terms of the contract, I will ratify the contract and whatever happen, I will assume responsibility for them. So if he said like that, he does not have to have full knowledge of all material facts. If he did not say that, he have to have knowledge of everything that happens before he ratified the contract. And then the principal must ratify the whole contract, and the ratification must not injure a third party. So the ratification of the agency must not cause any damage to a third party. So if you can follow all the 7 conditions, you can create an agency by ratification. So basically an agency created by ratification is an agency created after the transaction has come into place. Okay, and then the next one is an agency can also be created by necessity. So an agency of necessity may be created if there are if the three conditions are met. First one, it is impossible for the agent to get the principal's instruction. So for some reason, the principal is uncontactable. So it is impossible for the agent to get his instruction. And the second condition is the agent's action is necessary in order to prevent loss to the principal. So this is something urgent, something which is an emergency. So you have to do it now or never. If you did not do it now, you will the principal will suffer some loss. And then the third one is the agent of necessity must also acted in good faith. So the agent of necessity cannot be acting in bad faith. He must be acting in good faith for the benefit of the principal. So in an emergency, an agent has the authority to do all acts to protect his principal from loss, as would be done by a person of ordinary prudence. So if later you want to see whether the principal or whether the agent of necessity has done his job properly or not, you can compare him with another person of ordinary prudence. So if another person will do what he did, and it is done urgently, necessarily because the principal cannot be contacted, the agent is created by necessity. And then the last one is an agency can also be created by estoppel. Estoppel is what is the other words for estoppel? Okay, so when an agency is created by estoppel, the agency is created constructively by imposition of the law. So the law impose an agency for the parties. Because as a general rule, a person cannot be bound by a contract made on his behalf without his authority. But if he, by his words or conducts, allows a third party to believe that a particular person is his agent even when he is not, and the third party relies on it to his detriment, he will be stopped from denying the existence of that person's authority to act on his behalf. So in this situation, if you did not appoint someone, but you make the third party believe that the person is appointed by you, maybe for example, when someone is saying that, hey, I was acting on Samad's behalf. So if you want to do any transaction regarding Samad's property, you can talk to me. And then Samad heard that, but Samad did not see anything. So Samad does not agree to appoint that person as his agent, but by his conduct, he does not say anything. So he allows the third party to believe that the agent is his agent. So when the third party believe that a particular person is the principal's agent, because the principal does not deny, even though he does not admit, and the third party relies on that situation. So the principal in that situation, the principal cannot deny the existence of the agent because he knows that someone is acting on his behalf, but he did not do anything about it. So in the case of Chen Keng Hong against government of Federation of Malaya, it was held that when a principal induced a belief that the unauthorized acts of an agent are in fact authorized, he is bound by the consequence of such inducement. So if you as a principal knows that someone is acting without your permission, without your authority, you have to rectify that situation immediately. Because if you know but you did not do anything about it and someone else is relying on that, so you can be stopped from denying the existence of that person as your agent. So that is the fifth kan? Sixth. That is the sixth situation where an agency can be created. Yeah, I think that's all. Yeah. So that's all for how to create an agency. You have any question? Any question on how an agency can be created? No question? Okay, so if there is no question, we will continue with the next part, which is the duties of principal and agent. So as a principal, you have certain duties, and as an agent, you also have certain duties. Okay, so a relationship between the agent and principal is generally accepted as a fiduciary relationship. So it is a relationship of trust and confidence. So it's just like a situation of relationship between an employee and employee. So it is a fiduciary relationship whereby both parties need something from the other. So it involves trust and confidence. Okay, so under the law, the relationship of agency invokes equitable standards of conduct, which the fiduciary must observe in relation to the beneficiary. So if you have agency, if you have an agent, if you appointed an agent, if you have any contract of agency between you two, so if there is any contract signed between the principal and the agent, the rights and duties of the principal and agent will depend on the express and implied terms of the contract of agency. So if you have a contract, either it is an oral contract or if it is a written contract, all the rights and all of the duties of the principal and agent will depend on what is stated in the contract. However, if there is no contract, if there is no contract between the principal and the agents, so the rights and duties of an agent to his principal will follow the rights and duties of an agent as stated in Section 164 until Section 178 of the Contracts Act. So if you have a contract between the principal and the agent, the rights and duties will refer to whatever stated in the contract. But if there is no contract between you two, the rights and duties can, if you want to know what are the rights and duties of a principal and the agent, you can refer to Section 164 until Section 178 of the Contracts Act 1950. Okay, so referring to Section 164 until Section 178, the agent has 10. Yeah. An agent has 10 duties. So the first duty of an agent is to obey the principal's instruction. So if a principal made any instruction, for example, a principal appointed an agent to sell his house, and his instruction is to sell the house only if someone offers 250,000 ringgit for the house. So the agent has to obey his instruction. So the agent cannot sell the house unless they get a buyer who is willing to pay 250,000 ringgit, because that is one of the duties of the agent, to obey the principal's instruction. And the second duty is, in the absence of instruction, to act according to customs which prevails in doing the business of the same kind at the place where he carries on his work. So if the principal does not say anything about the price of the house to be sold, how much can you sell the house for? So if there is no instruction, you have to act according to customs. So in selling a house, usually people will sell it at a price agreed upon by the parties, or at least they will sell it according to the market price, the market value of the house. So in this situation, because the principal does not give any instruction on how much he has to sell the house for, he has to act according to the customs. So if customs say that usually people will sell the house at least according to the market value, so the agent have to find out the market value of the house and sell the house according to its market value. Okay, so that is the second duty of an agent. And then the third duty of an agent is to exercise care and diligence in carrying out his work. He has to do his work properly. He has to make sure that he did his best in doing his duty as an agent. He has to exercise care and diligence. He cannot be careless. He cannot be negligent in carrying out his work. And then the fourth duty
is to render proper account for all monies and property handled by him as an agent for the principal. So if the principal appointed him and allows him to the principal appoint the agent and he allows him uh, to accept money on the principal's behalf. For example, he has the right to accept money or to give money to the third party. So if in this situation, the agent has to prepare a proper account for all the monies and all the property handled by him. Anything given by the principal to the agent, anything received by the agent on behalf of the principal, he has to have a proper account, disclosing all the facts about where the money, when the money has come in, when the money is coming out, to whom it is paid, to whom it is received from. He has to have a proper account for all that things, and the account must be ready for the principal to check at any time. So if the principal wants to check on the account must always be ready for checking. That is the fourth duty. If you receive any money or if you handle any property on behalf of your principal, you have to have a proper account for all that. And then the fifth duties is to pay to his principal all sums received on his behalf. So if the principal is selling his house for 250,000 ringgit, once he get the 250,000 ringgit, he have to pay to his principal all sums received on his behalf. He cannot take any money. And then the agent also has to communicate with the principal. So if any situation arise, the agent must communicate with his principal for further instruction. So he cannot make decision on his own without referring to his principal. And then an agent must also not let his interest conflict with his duty. He must put his work above everything. So if something is in conflict with his own interest, he has to inform the principal on that. And then an agent also cannot make any secret profit out of the performance of his duty. So he cannot receive any bribe, or he cannot receive any under table money, any duit kopi out of performance of his duty. So if the agent has take any secret profit, the principal may either put an end to the contract, repudiate the contract, recover the amount of secret profit, and the principal may also refuse to pay the agent his commission or any other remuneration agreed, or the principal can also dismiss the agent for breach of contract, or the principal may also sue the agent and the third party giving the bribe for damages for any loss sustained. So as an agent, you cannot take any bribe, you cannot take any secret profit. Whatever you receive from the third party, you have to give it all to your principal. And then the ninth duty is you also cannot disclose any confidential information or documents entrusted to him by his principal. So if your principal has given you anything, any confidential document, any confidential information, you cannot disclose this confidential information or this confidential documents unless it is allowed by the principal. Okay, and then the last one, an agent also cannot delegate his duty. So unless the principal expressly or impliedly consents to an agent delegating his duties to another person, a delegate cannot delegate his authority. So if the principal appoint you to sell his house on his behalf, you cannot delegate your duty to someone else because a delegate cannot delegate. Okay, so that is the duties of a agent under a contract of agency. Next, we will look at the duties of a principal to agent. So what a principal has to do under a contract of agency, first, he has to pay the agent the commission. So if the agreement states that he will pay 3% of the 3% of the amount of the sale to his agent. For example, he has agreed that every time he get his agent sells a house on his behalf, he will pay 3% of profit to the agent. So he has to pay the agent anything agreed under their contract unless the agency relationship is gratuitous. This is what I said. If the agency relationship, if the agent does not want to receive anything from the principal from doing his job, he does not have to pay. But if there is anything stated in the contract that he has to pay the any kind of commission or any kind of remuneration, maybe salary or anything, he has to pay the agent. And then he also must not willfully prevent or hinder the agent from earning his commission. He must pay and he cannot prevent the agent from earning his commission. And then the third one, he also have to indemnify the agent for acts done in the exercise of his authority. So when the agent did something and what he did, he has done his best. He has exercised due care and diligence, but something happened, something wrong happened. So if something wrong happened, the person who will be responsible to suffer loss from the wrong things that had happened is the principal, because the principal has to indemnify the agent for acts done in the exercise of his authority. Okay, so anything wrong, then the principal has to pay for it. And then the principal also has to respect any lien the agent has over the property of the principal in the actual or constructive possession of the agent. So if there is anything, lien is actually referring to land. So if the principal has allowed the agent to put any kind of encumbrances on his land, so the principal has to respect whatever the agent has over the property of the principal. Okay, so the principal's duty is only 4. So basically, a principal has the duty to pay for his agent. So the main duties of principal is to pay the agent, and the second one is he has to indemnify the agents for any act done in his authority. Okay, so one more slides. Authority of an agent. So an agent's act are binding on the principal if they are done within the agent's authority. So if an agent did anything within the agent's authority, so if he is acting within his authority, their actions are binding on the principal. So for example, if he is instructed to sell a house for 250,000 ringgit and he sell the house at 250,000 ringgit, his act is binding on the principal. But if an agent does an act beyond his authority, he is allowed to sell the house at 250, but he sells the house at 200,000. The principal is not bound by the act of the agent. So authority of an agent, there are 2 types. The first one is actual authority. So actual authority is authority expressly given to the agent. So the authority may be something which is expressly stated, or the authority is something which is normal from the circumstance of the case, or the authority is something which is custom, so something which is usually done in that line of work. And the authority might also be expressed from the conduct of the parties. So when you actually have an authority to do something on behalf of your principal, that is when we call it an actual authority. But if someone does not expressly give you any authority, but when the court look at the facts of the case, the law regards the agent as possessing the authority. That is when we call apparent authority. So if it is something actually given, it is an actual authority. But if it is something not expressly given, but from the circumstances of the case, the court believe that an authority is given to the agent, it is called apparent authority. Okay, so that is an authority of the agent. Okay, so before we go to the last part, do you have any question on the duties of a principal or duties of an agent? No question. Okay, so if there is no question, we will go to the last part of the law of agency, which is how to terminate an agency. Okay, so if you look in the Contracts Act 1950 under section 154 until section 163 of the Contracts Act, it states the manner in which an agent's authority may be terminated. So if we look at section 154, so section 154 until section 163 talks about how to revoke an authority. So like section 154 states on how to terminate an agency, termination of agency where agent has an interest in the subject matter, when may principal revoke agent's authority. So you can look inside the Contracts Act on how and in what situation a contract can, an agency can be revoked. Okay, but we will look at 5 ways, 6 ways how an agency can be revoked. So the first one is an agency can be terminated by agreement. Okay, so when both parties agree that the agency shall be terminated, the agency can be terminated. So if both parties agree that they no longer want to be a principal and an agent, they can mutually agree to terminate the agency. How? First, both parties must agree that the contract is coming to an end. So both parties must agree that they don't want to be in a relationship of agency anymore. Okay, so when both agrees that they don't want to be in a relationship of agency anymore, if the agency is made by a contract, the provisions regarding termination must be observed. So if the agency is made by contract and the contract states that in terminating a contract, one of the parties have to send a notice for 14 days to the other party, for example. If there is any provisions on how to terminate the contract, the provision must be observed. The section, the clause must be observed, must be followed. So if there is any time frame concerning the length of notice, so if it states that if both parties want to terminate the agency, they must give 1 month notice, for example. So if there is any time frame which is stated in the contract, the time frame must be followed. But if there is no time frame, you must give reasonable notice of termination. So usually reasonable notice of termination will be around 2 weeks or 1 month. So you have to give the notice of termination. That is the first way, termination by agreement. The second situation, you can also terminate an agency by revocation. Revoke the authority. So the principal may revoke the authority of an agent at any time before it has been exercised to bind the principal. So for example, if a principal no longer wants to authorize a person to be his agent, he has to terminate that person before the person do any transaction which will be binding to him. For example, if you has appointed an agent and that agent is supposed to negotiate on an agreement on your behalf next month, for example. If you want to terminate that agent, you have to terminate him before he starts the negotiation. If the person has started negotiating with the other party and they have come to an agreement, at that time you can no longer revoke your authority. If you want to revoke the authority of your agent, you have to revoke it before he has exercised his authority. So how you can revoke the authority of your agent? First is by giving notice of termination. So termination by agreement, you have to give notice. If you want to revoke the authority of an agent, also you have to give a notice of termination. You have to give a notice saying that I am terminating you from being my agent, and after 1 month you can no longer act as my agent, for example. So you have to give a notice of termination. Or if the agent is in default under the agency, so maybe if there is a contract of agency between the principal and the agent has breached some of the clause in the contract, or the agent has committed some kind of wrong. For example, the agent has taken bribe without the knowledge of the principal. So in that situation, also the principal can terminate the authority of the agent. So that is the second way. Other than that, we also have a third way. So if a termination of revocation is when the principal revoke the authority of an agent. So the principal does not want to use the agent, does not want to authorize the agent to do things on his behalf anymore. So that is when it is terminated by revocation. On the other hand, if an agent does not want to work for the principal anymore, the agency will be terminated by renunciation. So revocation is when principal does not want the agent to work for him anymore. Renunciation is when the agent does not want to work for the principal anymore. Okay, so an agency may also be terminated when the agent relinquish or surrender his or her authority. So it is an unilateral act. So in this situation, the agent does not want to work with the principal anymore. Okay, so if the agency is for indefinite period, so in the contract it is not stated how long the agent will work for the principal. So it can be terminated by giving reasonable notice of termination to the principal. So if the agency is for indefinite period, so if there is no end date for the agency, if the agent does not want to work for the principal anymore, he can terminate his agency by giving reasonable notice of termination. So he have to give notice to his principal that I don't want to be your agent anymore. So the agent can claim reimbursement, can make claim for anything, for all his service, all his expenses, all his salary up to the date of termination of his agency. So he can claim whatever he has done on behalf of the principal up to the date of his termination. So if the agency is for a definite period, so if there is a fixed time of period, for example, it is stated in the contract that this agency is for 2 years. The agent cannot terminate the agency before the expiry of the period without just cause. So if you have a contract of agency which has a time limit, you cannot end it prematurely unless you have a just cause. So if you end your agency before the due date, before the end date, before the expiry of the period, you can be liable for damages. You can be liable for any loss suffered by your principal because you have prematurely ended your contract. That is termination by renunciation. And then there is also termination by performance. So if the agency contract is only for one single transaction, only for one single specific transaction, and the transaction is completed. So when the transaction is completed, the contract is brought to an end. So the contract ends once the transaction completes. Or if the agency is for a fixed period of time, the agency is only for 2 years. Once the 2 years is up, the agency contract will be terminated at the expiry of the period. It doesn't matter if the transaction has completed or not at that time, because it has a time period. And then we also have a contract of agency which can be terminated by operation of law. So if one of the parties die, for example, the principal die or the agent die, or the principal or the agent becomes insane, jadi gila, become unsound mind, or when the principal or the agent becomes insolvent, bankrupt, or the principal is a company and it was wounded up, it was digulung. In that situation, an agency will also be revoked. Okay, and then last situation is termination by frustration. Similarly, in the situation of a contract, just like a normal contract, a contract of agency can also be terminated by frustration. If an event happen which renders the agency unlawful, the agency may be terminated. Like in this case of Stevenson and I don't know how to spell it. In this case, an outbreak of war made the principal an enemy alien. So maybe this is a contract between a person in two different countries, and an outbreak of war made the one of the parties to become an alien because it is a contract between two countries. So at that time, the agency was terminated by frustration. Okay, so that's all for the law of agency. Do you have any question? Any question on termination of agency, or maybe if you have any question about how to create an agency? Basically, the agency is similar to the law of contract, the normal law of contract. Only a bit difference is an agency does not have to have consideration. So unlike a law of contract, if you want to enter into a contract, you must have consideration. It doesn't matter how little or how big the how little or how high the consideration is, there must be a consideration. But the law of agency does not require a consideration. But for others, it is quite similar to the law of contract. Only that if there is no contract between the parties, you can refer to the Contracts Act on what are the duties of the agent and the duties of the principal. So basically, that is the law of agent. When will we use this law of agent? Law of agency is actually used many times. Like I mentioned before, in any situation when you buy a house, where and you take out a loan for the house, there will be a power of attorney, someone who will act as an agent of the bank. And also when you want to buy something, when you want, for example, in normal situation, you want to find a house, you can engage an agent. Or if you want to sell a house, you can also engage an agent. So that agent will be responsible to find, if you are the seller, the agent will be responsible to find the buyer for you. Or if you are the buyer, the agent will be responsible to find a seller for you. So that is some examples of the relationship. That is some examples of how we can use an agent in our life. Or for example, when you are a big company and you have various smaller companies under your company, maybe each of that company will be an agent to the big company. So anytime you use a third party to act on your behalf, that is when you have a relationship of agency with that party. Okay, so this is the law of agent. Does anyone have any question on the law of agent? The law of agency? Okay, so if you don't have any question, okay, so if you don't have any question, for those who are inside my tutorial group, I already opened the link in UNIEC Virtual on the submission of your case study, which is your assignment. So your case study will be submission for the assignment, and the submission for the reflective paper, which is due next week. So the group assignment, you have to send it by today. I opened the link until 12 midnight today. And for reflective paper, you have to send it by next week. And one more thing, for presentation, we will start our presentation this evening. Depends on how short or how long your presentations. Maybe we will do 3 groups this week, or maybe we will finish all the groups this week. Depends. So for those who are inside my group, please send your presentation slides to my email. So my email, so this is my email address to send the presentation slides. Only presentation slides tau. Yang the other two, you have to send it to through the UNIC Virtual. So wait, I'll check how many have sent. I think most have sent. So Darshini's group has already sent their slides. Tivia's group already sent. Azida's group already sent. Which group is this? Ranina, I'm not sure who is this. So I already received.
Sabrina, madam. Sabrina's group.
Oh, Sabrina. Okay.
Okay.
So 4 groups are already sent. So another 2 groups, please send your slides before our class this evening. So if you don't have any question, I'll see you in the evening. Thank you.
Thank you, madam.